One of the most difficult concepts for folks injured in personal injury cases, in grasping the law, is the concept of fault versus damages or their injuries. Hi, I'm Guy DiMartino. I'm an injury and accident lawyer, and today I'd like to spend a few moments and discuss how this works in practice so you'd have a better understanding. This is how the conversation usually goes. The facts of the accident are really bad. The defendant was a jerk. The defendant's behavior was horrible. They did something wrong. There's no doubt that they did something wrong. They were speeding, they were reckless, they were on their cell phone, they were texting, whatever that might be. They really did something bad. But fortunately for the client did not get severe injuries. Their injuries were either temporary or relatively minor when you look at the injuries in regards to the defendant's behavior. So fortunately for the client gets better, and then the insurance company comes forward with their initial offer, and the client just goes ballistic. The injured person just says, I can't believe the defendant did A, B, C, and D, acted like a jerk, drove 100 miles an hour, was texting, was on their cell phone, and the insurance companies only offer me $15,000 or $20,000 or whatever it is. And they get their feelings hurt and they just go ballistic. And so this is what the client is actually doing. The injured person is actually mixing up the two concepts of fault and damages. You see, in order to be successful in a personal injury case, you have to show that the person was at fault and that you were injured and that whatever the person did actually caused the injuries. So the person's behavior, the fact that they were speeding or texting or on the cell phone or just being a downright jerk, all goes to the fault equation, does not go to the injury or damages equation. And if this matter were to proceed forward into court, most of the time the defendant's insurance company, their lawyer, is going to come into court and say, we were at fault for the accident, and so the judge is not going to allow you to get into all this egregious bad behavior, and the only thing that the jury is going to hear about are maybe slight facts of the accident and your injuries or damages. So this is a concept that really people need to understand, because liability or the facts of the accident might spill over into the damages or injury section and might sometimes drive value, but they are really separate elements of a personal injury case. If you have any questions about how this concept works, you can always give me a call directly on my cell phone at 352-267-9168. Thank you and have yourself a great day.